Yep. Morning, we're here.
All right, perfect. We can see you, we can hear you. Good luck and enjoy.
Thank you. Morning, everybody. We hope you had a good weekend. We are going to be talking today to you about terms and conditions of trading. This seems to be a very requested topic for us to discuss. So we're going to do our best just to give you some guidelines and some ideas of what you can include in your terms and conditions. And it is us again, Kim and Clinton. I think you're getting used to us by now, but in case you haven't seen us before, heard us before, here are our details. If you need to contact us after the presentation, there is our information. So, question, why should I have terms and conditions in my business? You can see my little pie chart there. Terms and conditions, red, I've read it. Green, I didn't read it. And the blue bit, which is the biggest, what are terms and conditions? So jokes aside, it seems to be quite a prevalent topic when people don't have terms and conditions and when they do have terms and conditions, i.e. what should I include in my terms and conditions, and if I do have terms and conditions, how do I enforce it? So why do we have terms and conditions? Firstly, it regulates the working relationship between you and your clients in whatever industry it is. It sets out your parameters of the scope of work that you're going to undertake for your client, and it allows for a payment policy. If you don't have the terms and conditions in place regulating these items, you may not even know, nor may your client know, what is expected of you, and your client may not know what is expected of them. So, these are the items that we have suggested to be included in a terms and conditions document: charges, your quotations and payments, the ownership, your warranties, your liability, and the costs, as well as the governing law. So we're going to be taking you through these very briefly and seeing exactly what should be included under your terms and conditions under these headings.
All right, so your charges are a very important thing to include in your terms and conditions. Okay, obviously it's important to be clear and specific. You must also allow room for unforeseen work. What that basically means is that you just need to make provision for those charges changing in the event that your work scope needs to be changed. And this also, obviously, the reason it's in there is to ensure that the client agrees to your rates. So it's very important to have a small little charges section, especially in the plumbing industry. You're performing a service. What you're selling is not only the parts, obviously, but you're selling your time. Just as an attorney sells their time, you're selling your time, and you need to make sure that the client is aware that you're not just selling them a piece of equipment. Your time is very valuable to you, and that they need to obviously compensate you for that time. Sometimes you find that a quotation is provided that says, you know, I'm charging you for this part, and there's a telephone arrangement where the client says, no, that your hourly rate of X is fine. You get there, you install the part, they're happy to pay for the part, but now they don't want to pay for your hourly rate because it's too much money. The important part is to set up a document that includes your charges in it so that they know from the outset, and they sign a document that says, I agree to your hourly rate as well as to your charges for all the goods that you provide and install for me. All right, so that's the gist of why you include the charges in your terms and conditions. The next thing that is important is your quotations and your terms of payment. So firstly, quotations and payment as they pertain to your terms and conditions, you need to deal with how long your quotations are valid for. For instance, if you quote somebody for a certain job, is it valid until the end of time? Will you do it for the same price no matter what, and no matter what the time is? Of course, that's not going to be the case. After a while, sometimes prices for certain goods go up. Maybe your rate has gone up, or if they ask you to do it on an emergency basis, it's obviously going to go up as well. So you need to set out from the outset how long those quotations are valid for. And you also need to make provision in your terms based on a lot of the queries I received or we received over the last couple of weeks, you need to make provision for the fact that a quotation given over the telephone, whether it's via WhatsApp or it's verbal over an actual telephone call, or if it's done by email, is a valid quotation. Okay, that just protects you in the event that the client ever wanted to say, oh, but I didn't sign any quotation, or you didn't give me a formal quotation and I didn't accept it, and then they thereafter let you do the work and don't want to pay. The point is to have your terms very specific to protect yourself so that there's no dispute at the end of the day with regards to what was agreed to. Right. Another important term that we identified based on the questions that were raised last week is that clients often ask for a breakdown of your costs. So in your quotation, you'll provide your quotation to the client, and in your terms and conditions, you must specify. If the client wants a breakdown, they must ask for a breakdown before the work is undertaken. They cannot dispute the charges after the fact that the work has been undertaken, because I assume, based on the questions, that is quite a big issue that is facing plumbers these days, is that the client only asks afterwards or disputes the charges afterwards. They accept the quote, work gets done, and then they say, no, sorry, I don't want to pay. Obviously, then you also need to include your payment terms. So this is specific to each of you. Some of you allow payments within 30 days, some allow within 7 days, some want payment with the invoice, some get payment beforehand. It's really, it's up to you how you want to demand payment, but it's very important for your terms and conditions to regulate this, just so that you have something to rely on and something signed by your clients. Generally speaking, we'll say that they need to pay upon presentation of the invoice. So once the invoice has been submitted, they need to pay right away. That allows you to take action immediately if they haven't done so. Whereas if you give them 30 days, they have a very long time to decide they don't want to pay you anymore. So you bear that in mind with your terms and conditions. I'm sure you'll see the terms and conditions that we've drafted sometime this week. So as far as quotations and payment goes, that's the important part with regards to your terms and conditions. But you must also remember that your quotations and invoices are 2 extra documents that make up the proof of the relationship you have with your client. So they've signed the terms and conditions. If you can also provide a quotation as well as an invoice, it just makes your case a lot stronger when you're trying to collect money from somebody who doesn't want to pay you. So just bear that in mind.
So another set of questions that we've received relate to ownership of goods supplied, i.e. do I retain the ownership until the customer has paid for the goods in full? And we suggest that the answer is yes, and that is a condition and term that is included in the document that your client sees and signs when you present the document to them. It is important to let your client know that you as service provider retain full ownership of the particular part that's been installed until they pay for it in full. If that is accepted up front, there shouldn't be any argument later down the line.
All right, let's just do, okay. So we have a little slide malfunction. We're supposed to have one that says warranties, because warranties are very important, and we've had very, very large numbers of questions come through about the warranties. There's a lot of confusion surrounding warranties, and that's why it's very important to regulate the warranty clauses in your terms and conditions of service. Right, so obviously we should identify the difference between the warranties. So you get a warranty on goods, and then you get a warranty on labor. Now, we had a question previously regarding a warranty on labor, and just so that we can come to a clear understanding of what each of these things is, a warranty on the goods means that the goods will last a certain period of time, and if they do not, you undertake to replace them. A warranty on labor means that if the goods are defective and they fail during their warranty period, during your warranty of labor period, you will provide the labor free of charge to replace that part. That's what a warranty of labor is. Okay, so that is only valid for a certain amount of time. Generally, the warranty on the goods outlasts the warranty on the labor. For instance, you have goods where there's a warranty for 2 years and your labor for 6 months. If the goods break after the 6 months but before the 2 years expire, you actually do have a right to charge for your labor in terms of reinstalling the replaced good. That being said, your terms and conditions, your warranty clause and your terms and conditions can cover this, and it can set other periods during which your warranty is lost. So we dealt extensively with manufacturer warranties because obviously the large majority of you will be installing geysers that are provided with manufacturer warranties. If you regulate that manufacturer warranty in your terms and conditions with your client, you can protect yourself a great deal. What you should say when you in your terms and conditions is that where a manufacturer warranty is provided, you will not provide your own warranty for any of the goods or services. In other words, the manufacturer provides the warranty. You will lodge the claim on behalf of the client, but if it gets rejected, it's not your fault. The client is under a duty to make sure that the terms and conditions of the manufacturer warranty are met so that their claim can be fulfilled. In addition to that, you can also specify that you will not provide a warranty on labor in respect of the manufacturer's warranty. So what that means is if the manufacturer provided a defective geyser, it burst, and the client then needs it replaced, you have legal grounds to charge for the labor it requires to reinstall a new part or to reinstall the fixed defective product. So that at least protects you in that way. That question was raised previously, and if there's no terms and conditions dealing with that, you'd be expected to cover the labor in respect of the good that was protected by the warranty. If you protect yourself in your terms and conditions, that would not be the case. Okay, so these are important to bear in mind because obviously it sets limitations to the warranties that you provide your clients, and you need to be specific about those warranties. All right, so let's move on to liabilities. These clauses in terms and conditions dictate who is responsible for what issues when they arise. Obviously, when you are plumbing or performing any service for anybody, you want to make sure that you have the least amount of liability and that the client cannot hold you liable for anything really. Okay, so it's very important for you to have this clause, and you'd want a clause that basically sets out that in the event that the performance of your work results in any sort of damage to the client's property, unless it's solely attributable to your negligence, you'll bear no responsibility. Because oftentimes you'll find that a client doesn't tell you something, a material piece of information, and as you go about your business, you hit a pipe you had no idea about or something along those lines, and it's not really your fault because you were not told that piece of information that you would have needed to know before you undertook the work. So it's important to have that clause and cover those specific scenarios where, for instance, the client hasn't told you something and that has caused damage to the client. You cannot be held liable for that if your terms and conditions protect you in that regard. So that's a very important term to include, and that is why we never have terms and conditions that leave that out.
Another clause to include in your terms and conditions relates to costs, and this is not in relation to the amount of money that your client has to pay for your service that you're rendering or the parts that you're installing. It relates to if there is a dispute and the client does not pay the invoiced amount, you are entitled as the service provider to institute proceedings out of any court in South Africa that is competent enough to hear the matter, i.e. that has the jurisdiction to hear the matter. So courts have got different ceilings of quantums, which means that it depends on how much money you want to sue your client for, whether or not that court is able to hear that matter. So the High Court has a quantum and the Magistrates Court has a quantum. There's also a possibility of going to the Small Claims Court and representing yourself. However, if you do not have this clause in your terms and conditions, it's going to make it difficult for you to claim the cost of the litigation back from your client if you do choose to go in the High Court or the Magistrates Court and not represent yourself in the Small Claims Court. So this clause will essentially refer to the the service provider instituting action out of any court in South Africa, and that your client who is disputing the amount due to you will be responsible for all the costs on the attorney and client scale, meaning that they would be liable for your costs that you incur with your attorney in order to sue them. And then last but not least, governing law. So this is which country, which court should I use in order to enforce my terms and conditions or to enforce the payment. You choose it in your terms and conditions. Obviously, it's going to be South Africa because your work that you're undertaking for your client is in South Africa. In determining which court must I use, we refer again to the quantum as well as where your client is based. The rule is, generally speaking, is we follow wherever the defendant is, wherever the cause of action arose. So if you do a job for somebody in Cape Town and you're based in Johannesburg and they are disputing the amount paid or they're disputing the workmanship, you are able to then sue them in Cape Town because the cause of action arose in Cape Town. That's just a very simple example. There are other factors to be taken into consideration, but that is just an example. So these are the suggested terms and conditions that we are making a recommendation, are included in your documentation that you provide to your client. It doesn't have to be a very big document. We have simplified it. We're going to fine-tune a couple of aspects and then submit it to IOPSA, and IOPSA will then review it and determine how they're going to release it to their members. So that concludes our part of the talk. Sean, are there any questions?
Morning. We do have a couple of questions and comments. The first comment reads, is it sufficient to have within terms that if a booking works in, client agrees to terms, brackets, we publish ours online, and the section is all our estimates and invoices, rather than having to obtain a signature, because it's sometimes difficult to obtain that signature.
Okay, so was that the first question all by itself? That was just one.
That was the first one.
Was the gist of it, can we put it online instead of give it to our client for signature?
I suppose so.
Okay. Sorry, the question wasn't easy to understand in the form it was put. So you can put your questions online. The only problem is if you have a client who, you can put your terms online, but if you have a client who comes to you through any other method and doesn't see your terms, they can easily say, no, I didn't see the terms and conditions, I didn't agree to those. That's the problem with putting them online. I have seen a few plumbing websites where they do just put them online. I understand that is easier, but that doesn't necessarily mean that your client is bound to them. If the client doesn't see them, the client can always argue, I had no idea that those were in existence.
I think also the one has to, if that is the route that one wants to take, is to get a specific confirmation from the client that they have read the terms and conditions online. There has to be an acceptance. One can't assume that the client has seen it, nor can assume that the client has accepted it. People will definitely use that as a reason to back out of payment.
What you can do is when you provide your quotation, at the same time you provide your terms and conditions, and you'll have a term on your quotation that says, if you accept the quotation, you accept the terms and conditions that were provided evenly with the quotation.
All right, perfect. And then the second question I've got you, I'm pretty sure it was answered last week and the week before, but just to confirm, it reads, how can we enforce ownership of the materials installed in clients' houses if they do not pay?
Right. So enforcement of that ownership clause is the same as an enforcement of anything else. You have to go through the proper legal methods. As I said, you can't jump over your client's fence and rip it out of the ground, or take the law into your own hands. What that does is it protects you in the event that there's any form of sequestration or liquidation of the person that you've done some work for, because if they haven't paid you, you still own it, so they can't sell it to pay their other creditors. So what it means is if you sue them and they have no money, you can go and take that back once you've successfully sued them.
All right, perfect. Well, that is all of the questions I have got for you this morning. Is there anything you'd like to say from your side before we end off?
No, I think we're good.
Yeah, everything's
But
fine.
if anyone does have some questions that they think of later, please do send them through. They also help us when it comes to tweaking terms and conditions to make sure that they fit everybody's requirements. So these questions do assist us.
All right, perfect. Well then, guys, I'm going to go ahead and end the session off now. Thanks so much for joining us this morning. Please do remember the survey on the way out, guys, and enjoy the rest of your week. Thanks, guys. Bye-bye.
Thank you. Thanks. Bye.